to the American Revolution, a person's right to be protected from unreasonable searches and seizures was virtually non-existent. British law allowed authorities to use what were known as writs of assistance, which were legal search warrants that were very broad and general in scope. These general warrants not only allowed the homes and other property of the colonists to be searched without notice, but also allowed for any goods deemed prohibited and unaccustomed to be seized. In 1789, speaking before the First Congress, James Madison recommended several amendments to be included in a Bill of Rights to be added to the new Constitution. In his speech, Madison proposed language that flatly rejected the idea of general warrants and secured the rights of citizens against unreasonable searches and seizures. Madison's words were adopted almost verbatim, and this provision became the Fourth Amendment to the United States Constitution.
The framers were attempting to strike a healthy balance between two worthy ideals that are often in tension, order and liberty. And the Fourth Amendment is perhaps the best example of that. No unreasonable government searches and seizures.
While the language of the Fourth Amendment was broad, it provided no solution for illegal searches or seizures or for the introduction of illegally seized items into evidence. It wasn't until 1914 that a case involving these issues came before the U.S. Supreme Court.
Weeks v. United States was a 1914 case, and it was a case that involved a plain violation of the Constitution, an unreasonable search and seizure. And the question in front of the court was, well, what now? The Fourth Amendment commands government to avoid unreasonable searches and seizures, but at first glance, the Fourth Amendment doesn't say, but if the government violates this constitutional command and perpetrates an unreasonable search and seizure, well, then what? And the court in Weeks was basically in the position of having to answer that question. What are the consequences if the government does what the Fourth Amendment expressly commands them not to do? And the Supreme Court decided that the appropriate remedy was the exclusionary remedy.
The premise of the exclusionary rule was to say, look, if the police, in obtaining evidence, violate the Constitution, they can't then use that evidence in the course of a criminal prosecution. Weeks v. United States, though, applied, again, only to federal prosecutions. And since Weeks only applied to the federal government, there were a number of states where, although the Fourth Amendment applied, in other words, police had to only search or seize reasonably, right? There was not any consequence for violation of the Fourth Amendment in the criminal trial.
35 years after the Weeks case, the Supreme Court once again heard a case regarding the admissibility of illegally seized evidence in state courts.
Wolf v. Colorado raised this question of whether the exclusionary rule that was announced in Weeks applied also to the states. Okay? So the court had already said that the Fourth Amendment should apply to the states, that in fact police at the state level also had to search and seize reasonably. But then the question was, what remedy follows from that, if any?
The original Bill of Rights, which included the Fourth Amendment, was held to apply exclusively to the federal government, and that seems consistent with the original understanding of the Bill of Rights. It was designed to limit this new and powerful federal government to protect certain enumerated rights, including the right to be free from unreasonable searches and seizures. What happened at the end of the Civil War, several amendments were passed to the Constitution that provided new and extensive restrictions on the state governments, not the federal government. One of those amendments was the 14th Amendment, which said that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The provision that's relevant to the exclusionary rule and its application to the states is the Due Process Clause. No state shall deprive any person of life, liberty, property without due process of law.
And so this was all referred to as the Incorporation debate. To what extent does the 14th Amendment's protection of liberty against state power, to what extent does that incorporate these fundamental rights listed in the Bill of Rights guarantees and make those freedoms that protect us not only from abuse of federal governmental power, but also freedoms that protect us from abuse of state governmental power. And Wolf versus Colorado was a very important holding in regard to that development, particularly as it applies to the Fourth Amendment and other of those Bill of Rights guarantees that clearly seem to affect the operation of a criminal justice system. And the court in Wolf said the Fourth Amendment right to be free in our homes, persons, papers, and effects from unreasonable search and seizure, that is a fundamental right that is implicit in the concept of ordered liberty. And therefore, the 14th Amendment's protection of liberty as against state governmental interference incorporates that Fourth Amendment right and makes it binding on the states.
At the same time, however, the court held that the exclusionary rule was limited to federal courts and was not constitutionally required of the states.
This meant that evidence seized illegally in violation of the Fourth Amendment was still admissible against the accused in state courts.
The idea is simply because the police officer today has violated your right to property doesn't mean that the state forfeits its obligation to prosecute people that commit crimes. The opponents of the exclusionary rule say, yes, the police officer did the wrong thing. Fire the police officer. Put him in jail, what have you. That doesn't mean the person whose murder we now have caught on videotape should walk out with a smile on his face. The flip side of it is the experience seems to suggest that the Fourth Amendment goes unenforced if you do not have the exclusionary rule in place. That the only way genuinely to deter police officers from engaging in this kind of conduct, or not the only way, but the best way, is to simply say, you're not going to be able to get the bad guy if you use these bad means.
In the summer of 1959, Cleveland, Ohio Police Sergeant Carl DeLau arrived at the home of Ms. Dolree Mapp. Sergeant DeLau and two other officers were searching for a man wanted in connection with a recent bombing and for evidence involving an illegal gambling operation. Known in the neighborhood as Dolly, Ms. Mapp refused to allow the officers into her home unless they produced a search warrant. Sergeant DeLau and his fellow officers eventually left, but returned a short while later, this time with several more policemen. When officers rang the doorbell, Ms. Mapp did not answer, so they proceeded to break down the front door and enter the house.
She hears this, she comes down the stairs, she meets him in the hallway. She says, where's your warrant? They hold up a piece of paper they claim to be a warrant. She suspects it's a fake piece of paper. She grabs the piece of paper and she stuffs it down the front of her shirt. Whereupon the police, in the language of the court, the police then rescued the warrant from her person, upon which she became belligerent because they were putting their hands down her blouse, and they rescued the warrant.
While the police did not find the bombing suspect or the illegal gambling materials they had been looking for, they did find and seize several books, pamphlets, and photographs which were considered obscene. At the time, possession of obscene material was a crime under Ohio law, and Ms. Mapp was arrested.
So here actually is a sort of classic exclusionary rule circumstance, right, where the crime is simply having some things that the state has said are illegal, and really the best evidence of the crime is the stuff that Ms. Mapp contended was seized illegally, because she said the police never had the right to enter my home in the first place. They didn't actually have a warrant.
During her trial, no search warrant was ever produced, nor was the failure to produce one explained. Nevertheless, the jury found Dolree Mapp guilty of possession of obscene materials, and she was sentenced to serve up to 7 years at the Ohio Reformatory for Women. Following her conviction, Ms. Mapp appealed to an Ohio appellate court and then to the Ohio Supreme Court. Both courts upheld her conviction. Refusing to give up, she made a final appeal to the United States Supreme Court. Of the 2,300 appeal petitions the court received that year, Dolree Mapp's was one of the few it agreed to hear. Oral arguments for Mapp versus Ohio were scheduled to begin March 29, 1961. Nearly 3 months after both sides had presented their arguments, the Supreme Court announced a 6-3 split decision in favor of Dole v. Mapp.
The court in Mapp versus Ohio said, states, your law enforcement agencies are not only going to respect people's Fourth Amendment rights, but your courts from this point forward are going to apply the exclusionary remedy, because history and experience are showing that that is the only remedy that police officers are going to be meaningfully responsive to. The reason that we could expect police to be responsive to that is because the very incentive for perpetrating unreasonable search and seizures is to find evidence of crime. And if you say that that evidence is consequently going to be inadmissible in court, well, that completely removes the incentive of executive departments of the states, the law enforcement agencies of the states to disregard the Fourth Amendment right.
Writing for the majority, Justice Tom Clark wrote
that the exclusionary rule is an essential part of both the Fourth and 14th Amendments is not only the logical dictate of prior cases, but it also makes good sense. Presently, a federal prosecutor may make no use of evidence illegally seized, but a state's attorney across the street may, although he supposedly is operating under the enforceable prohibitions of the same amendment. Thus, the state, by admitting evidence unlawfully seized, serves to encourage disobedience to the federal Constitution, which it is bound to uphold.
In his concurring opinion, Justice William O. Douglas summed up the majority's ruling this way.
If evidence seized in violation of the Fourth Amendment can be used against an accused, his right to be secure against such searches and seizures is of no value and might as well be stricken from the Constitution.
The court was saying the right against unreasonable searches and seizures by the state, particularly in one's home, was absolutely a core concern of the framers and is absolutely clear in the text of the Constitution. To announce that right and then effectively to have no remedy is really creating a situation where we're giving police carte blanche to violate the Constitution.
The court's dissenting justices believed that the majority had overstepped the boundaries of judicial restraint, and that since problems with criminal law enforcement varied from state to state, each one should be permitted to manage those problems without interference from the U.S. Supreme Court.
For us, the question remains, as it has always been, one of state power, not one of passing judgment on the wisdom of one state course or another.
The decision was controversial because it's unclear how it's rooted clearly in the Constitution itself. Many individuals, even those who defend the result in Mapp, will say, okay, it's a rule of deterrence. It's not exactly in the Constitution, but we need it to support the Constitution. And so the Supreme Court has a right to require that of the state courts in their criminal procedures.
It is always controversial to exclude evidence that tends to show that someone's a criminal, because the way the public sees the exclusionary remedy is, hey, there is truth. There's evidence that someone committed a crime that the justice system now isn't going to use, that the jury's not going to hear. But Justice Scalia has said it is a truism that constitutional protections have costs. So if you strike a healthy balance between order and liberty, there's going to be a cost to law and order in order to ensure that there is breathing room for liberty to thrive.
The case of Mapp versus Ohio was a landmark decision. With it, the Supreme Court turned away from precedent set in earlier cases, and it was one of several cases which addressed the extent to which the Bill of Rights applied to the states as well as the federal government.